Good afternoon, everyone. Welcome to Connecticut's Old State House. I'm pleased to welcome you on behalf of my colleagues here. My name is Rebecca Tabor-Conover. I'm the head of public programs. And today I'm pleased to welcome you to the fifth in our series on commemorating the Constitution of 1818, some of the discussions which took place here at our building. We are delighted to co-sponsor this program with our colleagues at Connecticut Explored. We do have some free magazines at the back of the room, and please help yourself to that. If you've not read it, Connecticut Explored is a wonderful resource, and I'm pleased to introduce the publisher, Elizabeth Norman.
Thank you very much. We're happy to be here for the fifth in this series. We have worked with the Old State House on turning all of this series into podcasts for Grading the Nutmeg, which we do with the state historian. We just put up the fourth one yesterday. So if you've missed any of the earlier, you can catch them either on the Old State House's YouTube channel, or if you want to listen on your phone, we have, and lots of other great stories in Grading the Nutmeg that we do, as I said, with the state historian, all kinds of different topics. It's really, really a lot of fun. Welcome you to do that. So this is the issue, the fall special issue, Constitution of 1818, a very special pull-out poster of the text of the Constitution, which I'm sure you will all want to immediately post on your refrigerator. And also, this particular topic today is very important and dear to me. I co-published a story with Ramin Ganeshram from the Westport Historical Society on this topic, so I'm very interested to hear what our scholars have to say. My feeling is that the story of black suffrage in Connecticut is not nearly well researched and documented enough. Women's suffrage is very well covered. The black suffrage, it's a trickier subject to get at because it's not as openly discussed and recorded. There's a lot of subtleties and language issues. For example, a lot of talk about universal suffrage in this period when they don't mean anything. They don't mean universal suffrage in the way that we mean it today. So it's a very interesting period to study, and I look forward to hearing the remarks today. So pick up a copy, read more about it, and thank you all for coming.
Thank you, Elizabeth. We also want to thank the funders of our program series, Connecticut Humanities, for their support. And I just want to put a plug in for the final program in this series, which will take place next month on November the 13th, so make sure to come back for that. And also on your chairs is a flyer for a 4-part series that will be taking place here at the Old State House on World War I, and the first of those takes place on October the 24th. Please do make sure to fill out your surveys on your chairs. We do read them, and we get ideas for future programs. Today's program, How White or Black Must the Voter Be? The Parameters of Suffrage and the Constitution of 1818, examines the Constitution's impact on suffrage in Connecticut. We're really excited to welcome our scholars today, and I did also just want to mention that if anyone is interested, we will be taking a tour through the building after the program. If you're interested in doing that, just meet me in the hall afterwards. And now, without further ado, I'd like to introduce our two speakers today. Dr. Peter Hinks has worked extensively in public history and historical editing. He is the author of To Awaken My Afflicted Brethren, David Walker, and the Problem of Antebellum Slave Resistance, and other essays and books on African American history in the 18th and 19th centuries. I got to know Peter when we served on the board of the on the Association for the Study of Connecticut History. And with a co-author, he co-edited the collection of essays in All Men, Free and Brethren, essays on the history of African Americans' Freemasonry. His research and writing are now focused on southeastern Connecticut, especially in the late 18th century. We're very pleased to have Dr. Douglas M. Arnold with us today. He'll be reading a paper on behalf of Dr. Bruce Stark, who was unable to be here today. Dr. Arnold is a professional historian of the American Revolution and the early American Republic. We know him here at the Old State House, most notably for his editing and publication of historical documents, including ones that we read a lot, the public records of the state of Connecticut. He also served as managing editor of a sourcebook on the U.S. Constitution and assisted with the establishment of a History and Archive Center in the city of Bridgeport, Connecticut. In addition to his independent work, he has been a faculty member and historical researcher at Yale University, and he was a senior program officer at the National Endowment for the Humanities in Washington, D.C. from 1990 to 2016. It is now my pleasure to welcome our two speakers, and we'll start off with Dr. Peter Hinks.
Thank you very much, Rebecca. I'm going to cut to the chase here, which means start reading the talk because we've got some time constraints here. I'd just like to say quickly, I can only second all of Elizabeth's very astute comments about the challenges of understanding what's going on with racial disfranchisement in Connecticut in the early 19th century. It still needs to be studied much, much more. There is a big problem confronting anyone interested in understanding the disfranchisement of African Americans in Connecticut in the 1810s. Virtually no sources commenting on or debating the measure exist. Scour newspapers, pamphlets, legislative debate, petitions, minutes of town meetings from 1814 and 1818, when blacks were denied the franchise first statutorily and then constitutionally, and the same result issues. Almost no commentary whatsoever is to be found on this fateful measure. Save for two fleeting references to possible black voting during debates over the suffrage clause in the proposed Constitution, I have not located even one passage pertaining to racial exclusion in all the other debates or voluminous printed commentaries from before or after the Constitutional Convention itself in 1818. Only a few years later, in 1821, New York would rewrite its Constitution while it granted universal suffrage for all adult white males. It levied a high $250 property qualification upon all potential black voters that disfranchised all but a tiny handful of them. Not only was this measure widely debated at the state constitutional convention, that is in New York, Connecticut on several occasions was cited as a key precedent by advocates for restricting or banning black suffrage. For example, one delegate promoted disfranchisement by observing that, quote, in nearly all the western and southern states, indeed many others, even in Connecticut, where steady habits and correct principles prevail, the blacks are excluded. Can we find even a few such brief and bold statements from our steady and principled legislators or citizens? No. This paucity poses problems for historians. Nevertheless, I do not think it makes interpreting this dark era in Connecticut's history insuperable. In the little time I have here this afternoon, I will at least begin to propose some tentative possibilities for understanding this disfranchisement. I have problems saying that, disfranchisement. Prospects for people of color in Connecticut actually appeared promising in the late 18th century. In 1784, the state enacted one of the first gradual emancipation laws in the young nation. Many of the state's most eminent white clerics, attorneys, and merchants organized in 1790 the Connecticut Society for the Promotion of Freedom and the Relief of Persons Unlawfully Holden in Bondage. In May 1791, Zephaniah Swift, a prominent attorney and jurist, addressed that society at its annual convocation, assuring its adherents that the legislature has enacted a statute founded in the highest wisdom and the best policy, which in its operation will not only eventually produce the abolition of slavery, but will secure to the Africans in this country the inestimable blessing of liberty against every species of encroachment and violation. In 1794, Theodore Dwight, editor, lawyer, and prominent member of the Connecticut Society, pronounced that slavery, quote, a relic of oppression, so odious and so wicked, will be speedily extirpated in the state of Connecticut. By doing strict justice to the Negroes, I presume is meant totally to abolish slavery and place them on the same ground with free white men, unquote. That same year, a radical law abolishing slavery totally in the state and guaranteeing to all African Americans, quote, the same legal privileges and justice and law within this state, which is general for the white inhabitants, passed the General Assembly in May 1794, only to be vetoed by the much more conservative Governor's Council. These orators and legislators identified people of African descent as sharing in common with whites a natural endowment of liberty and dignity infused in them by God and nature, an endowment slavery stole from them. Now, through the ministrations of liberty, religion, and education, they will be restored to their rightful inheritance. By the mid-1790s, Connecticut appeared to be among the more racially progressive states in the young Union. This wave of racial progressivism in the state, however, had crested by 1800. After 1795, the Connecticut Society steadily faded, perhaps in part because many of its members believed their work largely accomplished by setting the wheels of black freedom decisively in motion. After 1800, Federalists' emerging conflicts with Republicans dominated the attention of both parties, and earlier claims to concern for racial justice and equality fell by the way. Meanwhile, others found occasion to reevaluate black freedom altogether. Between 1800 and 1805, several vicious lampoons of African Americans appeared in key Federalist newspapers like the Hartford Courant. Leading congregational ministers and Federalists, the backbone of the state's stalwart standing order, evinced considerable cooling for securing, as Swift had said, the Africans in this country, the inestimable blessing of liberty. In about 1810, one such observer from Farmington wrote that the town's 30 free blacks were generally, quote, immoral, disposed to be intemperate, to disregard the Sabbath and its institutions, and are profane, indolent, and thievish. Another wrote that the 40 free blacks in Sharon afforded little in their condition, quote, to gratify the benevolent wishes of the inhabitants, indolent and thoughtless, they make no calculation for the future, and are too regardless of the means by which present enjoyment is secured, unquote. A leading cleric in Middlesex County wrote in the 1810s that the close to 400 free blacks there were largely, quote, addicted to low vices. Their education is much neglected, and the temptations to iniquity are suffered to operate upon them with the greatest force, unquote. At about the same time, Zephaniah Swift dramatically reversed his earlier enthusiasm. In a court ruling, he now presented the whole of Connecticut's free blacks as characterized, quote, by their idleness, dissipation, disorderly, and insolent behavior. Thus, quote, they have become the pest of any neighborhood where they reside. Yet, despite these fulsome detractions, other contemporary sources indicated that individual black property owners had only grown in number and enterprise, since the end of the Revolution. For example, a Wallingford official noted in 1811 that the town had one black man who possesses, quote, a good farm and who pursues his business with industry and success, unquote. Ridgefield had a black man in the 1780s, quote, whose property was acquired by his own industry and at his decease was inventoried at more than 500 pounds, unquote. Several black households in Glastonbury by the early 1800s each owned numerous acres of land and the house on them. Both Cato Freeman and Tobias Freeman were land and house owners in Newtown in the late 18th century. In the 1780s, London Freebody of East Granby owned a house, orchard, and 35 acres of land. In 1789, Cato Quashie purchased 34 acres of land in Ellington, along with other black members of the community. In New Haven, William and Reuben Lanson owned hundreds of dollars worth of land by the mid-1810s, as well as their own stable, hostlery, and quarry business, very successful. Yale President Timothy Dwight praised their characters and their wholesome, quote, attachment to property, unquote. And of course, Haddam Neck's famed Venture Smith had a substantial freehold by the 1790s. Throughout the state, there were other similar black landowners between the 1780s and 1810s. These individuals are important for our investigation because many of them would have qualified for freemanship, an official status necessary for any adult male who wished to vote. Historically, any adult man resident in a town and possessed of a certain quantity of landed property and of a good moral character could register as a freeman. Prior to 1814, no racial distinctions pertained to this status. How many such black property owners would there have been in the state into the 1810s, and how many of them were registered as freemen and voted? Bruce Stark has identified two, Toby Birdseye and John Jack in Wallingford. Were the black men I just mentioned, along with others in the state, registered? These questions demand research in town land records and in any available rosters of freemen, which towns may have compiled. The land records are readily accessible at the state library. The rosters, however, do not exist in its regular form. I've examined records of freemen for Heartland, Wethersfield, Glastonbury, Berlin, Durham, and especially for New Haven. Lists for other towns likely exist as well. They do exist. Racial designations are not used in these lists or in land records. Thus, one must know the names and locations of black individuals in order to seek them out. This research is painstaking, long, and possibly unfruitful, but nevertheless very necessary. As Walt Woodward aptly indicates in the splendid special issue of Connecticut Explored on the 1818 Constitution, which Rebecca and Elizabeth were just mentioning, as Walt says, we need more digging around in early town records on this matter to determine which, and even if towns admitted black men as freemen. My preliminary review of sources suggests that qualified African American males did not register as freemen. The most illustrative evidence is from New Haven, where among hundreds of names from 1769 into the 1820s, only one possibility of a black man was found. Otherwise, not one discernibly black name was found on lists from the municipalities mentioned above. I believe that exclusion of blacks from registering, from voting, and from broader civic participation in the decades after the Revolution was customary. While this impression awaits much fuller substantiation, and I emphasize much fuller, I offer some samples of suggestive evidence. A chronicler in Bristol, white chronicler in Bristol in the 19th century, recalled how in that town, African Americans, quote, were prevented by custom from voting or holding public office, unquote. The popular furor over the presence of a black elector in Wallingford, which we'll be hearing more about in a minute, the black elector was Toby Birdseye, in 1803, might point to the uniqueness of such a voter, as well as the Federalist strategy to argue that the corruption of the Republicans, the Jeffersonian Republicans, was so boundless as to stoop to seek a black man to support them. Moreover, Thomas Halsey, a prosperous black man in Groton, who would have easily qualified for freemanship, petitioned in 1808 that, quote, he hath always enjoyed the privileges of a citizen in all respects except the right of suffrage, unquote. One of the more revealing characterizations I have found is from William Lanson. In a petition Lanson and Bias Stanley wrote to the General Assembly in 1815, the two men, seeking relief from taxation since they had been denied the suffrage, commented ironically, and I'll quote it a little length here, that while they remember quote, that while they remember that God hath made of one blood all the nations of men, they are well aware that the feelings and prejudices of this community are so strong respecting the descendants of Africans that your petitioners will not complain of their disfranchisement, not complain, nor ask this honorable body to repeal the law in question. That they feel authorized, while they submit thus to be disfranchised without any fault on their part, and while they can have no representative here to plead their cause in the General Assembly, to come before, we thus come before this honorable legislature and ask that the people of color throughout this state shall be exempted from taxes. Lanson's clear awareness of the enormous force of customary disdain for black civic participation led him readily to relent from pursuing an enfranchisement, got it, to which he knew he was entitled, and to seek instead a waiver of taxation. His recognition is very significant because Lanson was then one among a number of black men who possessed the property and business requisite, according to conventional opinion, to feel the civic investment and motivation to want the suffrage and the portion of control it would give him over civic affairs. Yet he readily dismissed such a pursuit based on the popular state of mind and blacks' total lack of a voice in the state assembly. Other black petitioners to the General Assembly then seemed similarly cognizant. Seeking relief in 1818 from payment of the poll tax because of their disfranchisement, several black men from Norwich wrote that while their privileges fell, quote, short of what the principles of a Republican government guarantee, they nevertheless stated, quote, we have submitted to the deprivation without murmuring because we serve ourselves under the government of good laws administered by good men. Curious phrase, since these good men had disfranchised them. Two other propertied and prosperous black men in nearby towns, Lisbon and Griswold, similarly petitioned in 1823, both very successful black businessmen. But they petitioned in 1823 for a similar waiver, but added significantly that we, quote, do not now complain of our having no voice in elections, unquote. While, like Lanson, fully acknowledging disfranchisement, they all explicitly declined to challenge it, likely because of an equivalent awareness of the social realities. So, if black men were very possibly not voting in any sizable numbers in the state in the 1810s, why bother to disfranchise them? Good question. Let me propose a tentative explanation. First, a little background. During the War of 1812, antipathy against the Democratic-Republican administration of James Madison and earlier Jefferson had reached a fevered peak in Connecticut. The ongoing war with Britain had wrecked the Atlantic commerce crucial to the economy of New England. By late 1814, Federalist delegates from throughout New England gathered at the Hartford Convention to excoriate the war, President Madison, and their nefarious impact on the region. Jefferson's earlier Embargo Act in 1807, along with Madison's promotion of war against England in 1812, had been so unpopular in Connecticut that the state's Democratic-Republican Party declined dramatically. In a General Assembly with more than 200 members in 1814, the Republicans fielded 36 representatives as the number of their voters plummeted. This decline enabled a near total Federalist domination of the state politically. That dominance allowed them to pass new laws that placed greater restrictions on who might be designated a freeman. In 1813, the Federalist General Assembly significantly increased the value of property required for freemanship, while also mandating that the property must be free of any mortgage, and that the man be a resident of the enfranchising town for at least a year not just for months. And he had to be up to date with his local taxes as well. Federalists in Connecticut sought to constrain the qualifications for freemanship in order to limit the number of voters. As Bruce Stark reveals, the Federalist political experiences in the first years of the 19th century taught them that as the number of voters increased, so also did the threats to their hegemony. Thus, they enacted the famous Stand-Up Law in 1801 to monitor voting on statewide offices, and they controlled more closely the appointment of justices of the peace, who they appointed at the state level, who supervised the registration of freemen along with the locally determined Board of Selectmen and the constable. By 1805, they had successfully counteracted the Republicans' drive to secure, as they said, universal suffrage for all adult males. Connecticut's stalwart Federalists, often called the Standing Order, were no fans of what they derisively called democracy. That is, a social context where the mass of adult men, rather than just the adequately propertied, were enfranchised. That was among many components of their negative understanding of democracy. They had little faith in the intelligence and moral character of ordinary citizens, white or black, and were certain that if such unlettered and unruly men gained power, they would act against the property and status of their betters, that is, the Standing Order. The actions taken in 1813 were done to limit further the possibility of such men becoming freemen. As Richard Purcell has aptly written, quote, Federalist leaders were aroused to the defense of the property qualification, well aware that its removal would mean a Republican victory, unquote. Yet in 1814, a further step was taken. The franchise was restricted to white adult men exclusively. Why exactly this provision was added at this time is not clear, because, as noted earlier, no commentary on it exists. Yet, given what we have just noted about the Standing Order's attitude towards the democracy, combined with the derogatory comments of Zephaniah Swift and others above on the nature of black character, we should not be surprised that the arch-conservative Standing Order, of which Swift was a key part, sought such a provision. At a time when Federalists' near total control of the state government enabled them to sharply curtail access to freemanship, disfranchising black men might be understood as a sort of gimme. The fact of African Americans' highly uncertain civic status left them readily vulnerable in the state to such an action. It was an easy strike against the disorderly mass of ordinary citizens as a whole. The Standing Order did not hesitate to pocket it. Thus, I will make bold to offer the following hypothesis. The fact that black disfranchisement is enabled in the broader context of the passing of sweeping Federalist restrictions on freemanship suggests that they understood that disfranchisement as yet one more part of their overall project to restrict access to freeman status. Even if blacks may not have been voting, the Federalists may have taken advantage of their supremacy to preclude any possibility whatsoever that the Republicans or whomever might get them mobilized along with the many adult white males who in fact remain disfranchised as well by the stiff requirements for freemanship that the Federalists had now installed. Several examples of Federalist racist lampoons of Connecticut African Americans in the early 19th century reveal their fears of precisely such a mobilization of them by the Jeffersonians. While their overriding concern was to restrict white freemanship as much as possible, they recognized that prudence and opportunity demanded a timely excision of all possible challenges, even the remote. By 1818, disfranchisement in Connecticut was already a fait accompli in the governance of the state. The work of installing it had already occurred in 1814, when the expanding number of Republicans and tolerationists in the General Assembly liberalized suffrage laws in May 1818 and reaffirmed them at the Constitutional Convention in July, no objections whatsoever were raised about the disfranchising of people of color, save for a few fleeting comments at the convention itself proposing the possibility of retaining the vote for a few black men under the old system of freemanship. The authors of the 1818 Constitution inserted the provisions of the 1814 measure into it almost reflexively. 1818 did not make the negative innovation of disfranchisement in Connecticut. 1814 did. And while all parties, Republicans and Federalists alike, share blame equally for embedding disfranchisement in the civic fiber of the state in 1818, it was largely the Federalists in 1814 who did in fact launch it. Thank you.
Good afternoon, everybody. I'd like to remind you that my name is Douglas Arnold, but the paper that I'm reading is by Bruce Stark, who can't be with us today. I thank Peter Hinks for asking me to do this, suggesting that I do it. I've been friends with both Bruce and Peter for a long time, and I'm glad to be here today. This is a paper that Bruce wrote on the franchise in the Constitution of 1818, and Bruce opens up with actually reading the provision from the Constitution of 1818 regarding the franchise. I'm going to more quickly summarize it. Basically, it said, every white male U.S. citizen who had a settlement in this state, was 21 years old, and resides in the town in which he asks to be part of in the franchise, and having a freehold estate of the yearly value of $7, and being of a good and peaceable disposition and moral character, shall be admitted as an elector. The key elements of the section concern age, property, race, and character. It is important to stress that not all aspects of Article 6, Section 2 were of recent origin. The minimum age to qualify for voting had always been 21, and the character qualification was likewise a long-standing one. With regard to this section, with regard to character, the section denied the vote to those convicted of bribery, forgery, perjury, theft, and fraudulent bankruptcy, among other crimes. The parts concerning property and race, however, had recently changed. With regard to property qualifications, the critical alteration occurred in May 1818, when the legislature, controlled by the Toleration Party, an amalgamation of longtime Jeffersonian Republicans and disgruntled former Federalists, liberalized the voting qualifications in language that was virtually identical to that found in the Constitution of 1818. This act marked the victory of the universal suffrage movement, on which Peter has just talked about, one that began in 1802. The Constitution did not simply state that all white men 21 years of age or older were qualified to vote. It stipulated that the potential voter had to meet residency requirements and one of three other conditions: a freehold estate worth at least $7, service in the state militia for at least 1 year, or being excused from participation in it, or had paid state taxes the preceding year. These conditions were not onerous, and virtually all white men qualified. Universal suffrage for white males. Likewise, the limitation of the franchise to white men was not entirely new either, but was the result of legislation passed by the General Assembly in May 1814, again as Peter has discussed, that added a new qualification for freemanship. In addition to the qualifications already required by law, he be a free white male person. Now, this story really begins in October 1801, when the Connecticut General Assembly, controlled by nervous Federalists concerned about the growth of the Jeffersonian Party after the election of Thomas Jefferson as president in 1800, passed what became known as the Stand-Up Law, Paragraph 4 of that law required that when it came to the nomination of assistants or representatives in Congress, all those who wished to vote had to signify, quote, signify it by rising, or when the accommodations will not admit of the freemen's being seated, shall call upon them to vote by holding up the hand. All efforts to repeal this section of the law over the next decade and a half failed. In October 1802, the so-called universal suffrage movement was launched when Jeffersonian John T. Peters of Hebron introduced a bill to change the qualifications for voting. Paragraph 1 of that bill proposed that all inhabitants of the state, at least 21 years old, who were people of quiet and peaceable behavior and civil conversation, liable to the payment of taxes or by law excused from putting in a list of their polls or estates, may be admitted and made free of this state. That's an exact quote. You will note that the character qualification is the first one listed. This bill was rejected by a more than 2-to-1 margin, but the issue over universal suffrage was joined, and Connecticut newspapers published a series of articles on both sides of this subject for several years thereafter. Other bills promoting universal suffrage were introduced in May 1804 and May 1806. But with the passage of the Embargo Act by the federal government in 1807, followed by the Non-Intercourse and Unpopular War of 1812, Non-Intercourse Act, and the Unpopular War of 1812, the Jeffersonian minority entered a dark age from which it only emerged after the termination of the conflict. Thus, its proponents made no further efforts to promote the widening of the franchise until 2 years after the war ended. What about the question of limiting the franchise to white males, a matter intimately connected with universal suffrage? For what is likely at least a partial answer, we need to look at events in the town of Wallingford from 1801 to 1803. Wallingford was one of a handful of towns at the beginning of the 19th century in which the Federalists were a distinct minority. The town's pro-Jeffersonian sentiments first found expression on February 23, 1801, after the U.S. House broke the electoral tie between Jefferson and Aaron Burr. Once the glorious news had been received, Republicans launched a project to hold a festival in Wallingford on March 11, 1801, 1 week after the inauguration of the, quote, illustrious Thomas Jefferson. The leading Jeffersonians in the state spoke to an immense crowd of some 2,000 joyful Republicans. Wallingford had a second Republican festival on March 11, 1802, attended by a respectable number of Republicans of Connecticut to celebrate the anniversary of the election of Jefferson and Burr. Again, that was a quotation. A year later, the universal suffrage movement took a decisive turn when the issue of African American suffrage came to the forefront. 2 newspaper articles about voting in Wallingford in April 1803 launched the controversy. The first, published in The Visitor of New Haven, stated that, quote, it is a fact which can be proved in a court of justice that at the freemen's meeting in Wallingford, a Negro fellow was admitted a freeman of this state and sworn, and voted on the Democratic side, who had been convicted of an offense and publicly whipped at the post. A majority of the civil authority and selectmen were Democrats. Here, fellow citizens, is a display of democracy, end quote. The Connecticut Current of Hartford, of course, followed on May 11, 1803, with its take on what happened at the Wallingford Freemen's meeting. The title was Universal Suffrage. The article began with the statement that at the 3 most recent elections, quote, many young men have offered themselves by the influence of the Democrats to be made free of this state, more than 3/4 of whom by their own account were not legally qualified to be freemen, as they did not possess the real or personal estate required by law to entitle them to the freeman's oath, end quote. The Jefferson majority of the civil authority and selectmen, despite protests from the Federalist minority, admitted all the candidates to the freeman's role in direct contravention to Connecticut law. If this was not bad enough, quote, these friends of the people and the people's money had the effrontery to bring a Negro fellow by the name of Toby and offer him to be made free of this state, end quote. With regard to Toby, quote, a few years since, this man of color, end quote, attempted to rape a white woman. Toby was caught, confessed his guilt at trial, and was, quote, by the order of the court, publicly whipped at the post. The article also asserted that everyone at the Freemen's meeting knew of Toby's history, and the Justice of the Peace who tried his case endorsed his admission. I should add as a note here that although this was the report as given in the current, there has been no one has found any court records relating to Toby's conviction on this charge. The article prompted a newspaper debate that lasted more than 2 months, with the Federalist Current and the Jeffersonian American Mercury slinging arrows at each other on universal suffrage and illegal admission to the freemen's rolls. The Mercury argued that the property qualification was unfair, but did not deny that Toby had been convicted of attempted rape and endured a whipping. For a period of some 2 months, Toby's name permeated the Connecticut press. Who was Toby? We don't know much about him. His surname was either Birdsey or Birdseye. He was manumitted in April 1798 when he was around 30 years old. He purchased a small amount of land in the same year, was the head of a household of 4 free blacks in 1800, and died in Southington in March 1811 at age 45. Toby became the symbol of what could happen when unscrupulous politicians rode roughshod over the voter qualifications in Connecticut law. Had he not so notoriously failed to meet the character standard for freemanship, his admission would likely to have caused no controversy and been unnoticed. In the context, however, of the struggle between the two parties to control the state's government, the Wallingford election controversy proved to be toxic. Toby Birdseye was a pawn used by the Jeffersonians for their own political advantage, and the matter blew up in their faces. The Federalists played the Toby issue for all that it was worth because it fit one of their narratives that the opposition party attracted all sorts of worthless men who did not deserve the privilege of voting. Moreover, on several occasions, the Federalist press made extremely derogatory statements about African Americans and their relationship to the Jeffersonians. To cite 2 examples, the author of the May 1803 Universal Suffrage article used italics for emphasis when referring to Toby, with such words and phrases as, these are all in quotes, friends of the people and of the people's money, man of color, citizen, worthy citizen, useful labor, and reap his reward in the thankfulness of Jacobins. 3 months earlier, an article addressed to all good people of color, entitled Glorious News by a Semi-Literate Fictional Man of Color, mocked a forthcoming Republican festival being held in New Haven in March 1803. The piece contains a number of misspelled words in a caricature of African American speech, including such phrases as great Thanksgiving and a very great dance. This devastating portrayal of Connecticut people of color was designed to belittle blacks and ridicule the pretensions of Jeffersonians who are going to gather to celebrate the 2nd anniversary of Jefferson's inauguration. The only reference to voting prior to 1814 the partisan effect of the admission of Toby Birdseye tarnished the case for any broadening of the franchise and jeopardized any hope for African American suffrage. The only reference to voting prior to 1814 by an African American came from a March 1808 petition by Thomas Halsey of Groton in the New London County Court. Halsey stated that in February 1808, the selectmen of Groton had, quote, willfully and maliciously, end quote, with an intent to deprive him of his, quote, natural liberty and to deprive him of improving his estate, had appointed an overseer over him under the terms of an act for relieving and ordering of idiots, impotent, distracted, and idle persons. Born a slave, he was freed in 1779 and by hard work had acquired an estate worth $2,500. He stated, quote, your petitioner hath from his youth to the present time sustained a character fair and honest with all good citizens of the state, that he hath always paid his public taxes as well as his private contracts with punctuality, that he hath always enjoyed the privileges of a citizen in all respects except the right of suffrage. He requested that the actions of the selectmen be annulled and that he be restored to his, quote, natural rights and privileges of a citizen, end quote. The court granted his petition. Halsey implied that his estate was taken away from him because he did not possess the right of suffrage in the town of Groton. It is highly unlikely that he ever applied to become a freeman. Still, the fact that he raised the issue indicates that perhaps he and other people of color had begun to think about this possibility. 6 years after the Tom Halsey petition, the legislature limited voting to white males. This was not an isolated action and needs to be seen in the context of other legislation passed during the War of 1812. In May 1813, the Federalist General Assembly passed an act stipulating that no person could be admitted as a freeman unless he possessed a personal estate of at least $134, exclusive of polls and assessments, that the estates had to be free of mortgage, and that the male lived in the towns at least 4 months prior to admission. A second law passed in October 1813 increased the residency from 4 months to 1 year. The Act of May 1814 had first 2 sections. The first stated that representatives to the General Assembly had to be elected by ballot, and the second added the provision concerning the admission of freemen that, quote, in addition to the qualifications already required by law, he be a free white person, end quote. With regard to the limitation of freemanship to whites, no public outcry led to the passage of the law, and none occurred after it was passed. Often legislation was predicated on some sort of public pressure, like a petition to the General Assembly asking that a specific action be taken. Nothing of the sort existed, and Connecticut's newspapers did not publish a word on this subject. Newspapers for the period provide no information whatsoever, except for printing the law along with the other acts passed by the General Assembly in May 1814. The first known response occurred in an October 1815 petition to the General Assembly by 2 New Haven men of color, Bias Stanley and William Lanson, who, quote, although of African descent, are both free and native to the state of Connecticut, end quote. They stated they were, quote, persons of a quiet and peaceable behavior in civil conversation, end quote, and had amassed enough property, quote, to qualify them as freemen, end quote. They pointed out that they and, quote, other black men of this state are singled out from the other citizens and deprived of one of the highest privileges of a free citizen, end quote. They concluded with this request, quote, wherefore they pray to this General Assembly in behalf of themselves and the rest of the men of color to enact that the people of color throughout the state shall be exempted from all taxes whatsoever on their property and occupations, end quote. The legislature took no action. In January 1817, Eber Quay, a quote, black man, quote, from Norwich, wrote Governor John Cotton Smith to protest the recent imposition of a poll tax on people of color, end quote, by the selectmen. Quay argued that they had never before been required to pay the toll poll tax, that no other town imposed the same demand, and that, quote, if we must pay taxes, the same as white people, our request is that we might have the same privilege of voting granted to us as the white people, end quote. The governor replied that he had no power to intervene and recommended that he pursue the grievances in the courts. The next protest occurred in May 1818 with a memorial to the General Assembly from 10, quote, free persons of color, end quote, from Norwich. The petitioners stated that, quote, we have been denied the exercise of the right of suffrage and have no voice in the enactment of laws to which we are subjected, end quote. The crux of the matter concerned the poll tax. Quote, we believe it never was intended that persons in our condition should be subjected to a capitation or poll tax, end quote, as it was imposed by the town of Norwich. Quote, all we ask is this, that we should either be exempted by an express law from the payment of the capitation or poll tax, or be admitted with the white male inhabitants of this state to an equal participation in the right of suffrage, end quote. The legislature rejected the petition. So what then are we to conclude about the restriction of voting to whites in 1814? And did events in Wallingford revolving around Toby have any influence on this legislation? If newspapers can be believed, the dispute riveted Connecticut during the spring and summer of 1803. One looks in vain, however, for any direct connection between what happened in Wallingford in 1803 and the 1814 legislation. But one can speculate that the Toby Birdseye case had some effect, although the uproar presented just one episode in the context of larger issues concerning the broadening of the franchise. And the question remains, did the 1814 law in fact disenfranchise people of color in Connecticut? The only conclusive evidence that exists points to just 2 African Americans from Wallingford, Toby Birdseye and Jack John, who ever voted, and probably only once, and none of the protesters between 1815 and 1818 ever claimed that they had been electors and that the franchise law of 1814 denied them a right that they had previously exercised. What they did was argue that since they were denied the right to be electors, they should be exempted from taxation. And as Peter points out, racial attitudes had changed between 1790 and 1818. Initial optimism about the potentiality of freedmen to be worthy of full citizenship dramatically changed due to the difficulties of the first generation of free African Americans had in trying to live in a white world. This too could well have been a factor leading to the passage of the 1814 legislation. What was far more important, however, were mundane factors. Connecticut law had always denied minors, people without property, women, Native Americans, dependents, and slaves the right to vote. The drafters of the legislation likely considered the addition of the word white to be merely a technical change to clarify what had always been the general understanding of voting privileges. Prejudice against African Americans almost certainly entered into the equation, as did the repercussions of the 1803 Wallingford controversy. But more fundamentally was the need to write into law what had always been accepted, and the right to vote, that the right to vote was solely reserved for white males.
Thank you to our speakers. Does anyone have any questions that they would like to? And actually, we'll just bring a microphone to you.
Okay, all right.
We're recording it, so that way we'll get a question.
So this is just a quick question. How did they discern who was black or white?
Very good question. I mean, they had the same problems down south after the Civil War when we're putting all these Jim Crow voting laws in place. And in fact, during the convention, the debates around during the Constitutional Convention in 18 and in July 18, one delegate actually asked that question. Precisely, how do we determine? I get these things confused, but these debates confused. This might be from New York in 21. But someone said, we have, there might be people who are not recognized as Africans in any way, but who might have darker complexions, who are coming into the country from wherever. And he may have actually cited people coming from India, and probably would refer to them as Hindu, Hindoo. They said, can they vote? And okay. Yeah, so I think that's a very good question. It's a problem. I mean, finally, you have to, if you're going to impose racial restrictions on voting, you're going to perhaps have to have some method in place for determining who's in the privileged racial group, definitively.
The second part to that would be, how do you go about finding out who was who when you're researching the records? I mean...
And Peter, do you want to just repeat that question so we have it?
Yeah.
Or, yeah, if you could, yeah. Yeah, if you could repeat your question, please.
So
Thank you.
my question then to you is, if you're researching this, going from town to town, how do you figure out who was black or white or Hindu?
In some cases, I just know the names and know the people who are African Americans. And good question. And I know of a number of names, especially say for Eastern Connecticut, New Haven area. I'm just familiar with many names, and Wallingford, as is Bruce. But it's a good question. I mean, you could be reading lists of freemen or looking at land records and see a name and not recognize it. And it might be a black individual, not specified on either of the lists, the land records or the freeman list. And you could overlook that individual. I mean, these things can happen. So maybe there's some, in the list that I looked at, freemen, maybe there were black men in there, and I simply didn't recognize them as such. But the names that I know, you know, I did not see them appear in the list that I reviewed, which is a limited sample of lists.
Thank you. Any other questions? Oh,
Hi, thanks for your talks. Do we know when the next changes in the Constitution took place that affected voting eligibility?
Yeah, once the 14th Amendment is passed, Connecticut has no choice. They got to change the Constitution. That said, they may still have delayed. Blacks were voting in South Carolina in 1868, before blacks were voting in Connecticut.
wow.
I mean, it's pretty amazing. Where 4 years earlier, I'm sorry, am I not holding this properly? 4 years earlier, blacks were still enslaved in South Carolina. So that, there are efforts on the part of very determined black activists, such as Amos Beeman and others, some white supporters, Simeon Jocelyn, in the state, in the 40s to have a referendum on reinstating the black franchise. They generate huge lists with largely the names of black men attached to them, petitions, but some white men as well. And those referendums are, I believe there were referendums possibly in 48 or 44. Those referendums were not passed. So there was that prior to the Civil War, and then, of course, the 14th and 15th Amendments, which forced Connecticut to have to reinstate black voting, black male, adult black male voting.
Thank you. Any other questions? Well, thank you all for joining us today. Please come to the 6th and final program on November the 13th, and if you could hand in your surveys, that would be great. For those of you who want to join our tour, we'll be starting out in the hall. Thank you both to our speakers today. It was delightful to have you, and have a nice afternoon.
Thank you.